Okay, welcome to Chapter 31, Bankruptcy Law. This is a revised chapter and which that we're going to be updating to some of the numbers for late 2020 to early 2021 as some of the new numbers that have come in, particularly in regards to dollar amounts and that are modified by bankruptcy. More about that in 1 second so you won't get too confused. Okay. The first thing to talk about here, of course, is bankruptcy law itself. Now, almost like any other law in the United States, where there are 50 different systems of real property, 50 different criminal law systems, and then the federal system, so I guess 51. For bankruptcy, there's just the federal system with some small state modifications, which I'm going to talk about at the end. Basically, there is no state bankruptcy court. Now, there have been different iterations of bankruptcy throughout the history of the United States. There was a code very early on in the early 1800s. It was revised. It was abolished. There was one that was brought in the 1850s, I believe, another one in the 1870s. The current modern bankruptcy code begins right around the turn of the 19th to 20th century. So the first modern bankruptcy code was enacted in 1898. The current law that we see was another heavy revision that was 70-odd years after that. That was, or 80-odd years after that. That was the Federal Bankruptcy Code of 1978. In 1994, there was some changes to that that upset some of us that were trying to practice. In 2005, there were even more modifications. Those tended to be more friendly towards creditors, and they were called the Bankruptcy Abuse and Prevention and Consumer Protection Act. One of the things you have to appreciate is there's a struggle in bankruptcy codes, just like there's a struggle in the Congress between people that owe money, which is the bulk of the population, debtors, and people to whom they owe the money, the creditors, the banks, the MasterCards, the Visa, the American Express, the Discover cards. So there's a tension between these two groups that is reflected in the Bankruptcy Code itself. So the way bankruptcy is broken down is you have the United States Code, what's called USC, and USC has a title, which is that first number, and then it has chapters. So Bankruptcy Code is Title 11, and then we have chapters 1, 3, 5, and we're particularly concerned with 7, 11, 12, and 13. We're concerned with those because that's generally what people call the different types of bankruptcy. So you'll hear something like, okay, it's a Chapter 7 bankruptcy, or a straight bankruptcy, a liquidated bankruptcy. That's the one most people think about when they think about bankruptcy. Chapter 11 is a reorganizational bankruptcy. This is when you're trying to really kind of catch up and change how things were. Buy yourself time. Then we've got some special provisions for farmers, very common in all law that there are special rules for farmers. That's Chapter 12. And then Chapter 13, which is a kind of a newer form of bankruptcy. It's a rehabilitation plan. It's a consumer rehabilitation plan. More about that when we get to it. Okay, so when we think about bankruptcy, I want you to think about the model of a will, a trust, a death. When someone dies, they make a pile of all their money, everything they owed, and then they farm that money out according to the will. And if you owe money when you die, the people you owe money to are going to get money under that will. If you have more money than you do debts, then your heirs will get money. And that's a lot of how a liquidated bankruptcy works. Basically, the debtor puts all his assets into a pot, and this is the bankruptcy estate. And this is turned over to a trustee. Now, he doesn't get ownership, but he gets control over it. And what this trustee does is he pays all the debts that the person in bankruptcy has. And if he can't pay all of them, he pays a percentage of them. And at the end of it all, a discharge is issued to the debtor, and there's no more debt. Even if there wasn't enough money to pay everything, the debt is wiped out. Now, Individuals can claim a Chapter 7, corporations can claim 7, and the federal government allows bankruptcies to claim 7. The way this starts is a petition. I'm going to show you a sample petition in a minute, but most bankruptcy is voluntary. Most of the time people will come in and they will say, I'm in a lot of trouble. I really need to get out of this. There's no way I am getting out of it. I just get deeper and deeper in debt. Things are getting worse and worse. I need to declare bankruptcy. That's a voluntary bankruptcy. Someone recognizes their situation, they decide to take that route. The involuntary petition is slightly different. That is where your creditors force you into bankruptcy. Now, that's not as common, and we'll talk about some of the unique natures of that in just a minute. But the voluntary petition, which is how it starts at first of all, a few roadblocks are placed for you. You've got to receive information to avoid bankruptcy. So the clerk of the bankruptcy court says, have you read this? Have you seen this? And then the assistance is also available from credit counselors, because the people to whom the money is owed don't want you to declare bankruptcy. That's not in their interest. When you create this petition, it's going to give your name, obviously, but it's also going to say who you owe money to. And it's going to categorize those debts as who you owe money to that is secured, that they have some sort of claim on collateral, or unsecured creditors. Then you're going to provide a financing statement. You're going to give us a list of all your assets, including those that might not be ultimately part of your estate that you're going to be able to protect. We're going to take a list of your income, a list of your expenses. That's always fascinating when you sit down with someone getting ready to do that. You have to have a certificate of credit counseling, and this is one of these extra steps that they put in there for you to jump through, hoop to jump through, or step to make it a little bit more difficult to declare bankruptcy, because people were, particularly creditors, felt that it was too easy. Proof of payment from employers, monthly income, and this goes back to your income and expenses, itemized, and a copy of a recent tax return. Now they've really changed some of these. This is the older form here on the left, and you can see it looks a little bit more complex, and they really simplified it about 2012 or so. That's a sample form, and they made it a little bit easier to file bankruptcy in that regard. So those weren't necessarily in your book. I thought I'd show you what they look like. Okay, so it goes to the bankruptcy court, and one of the things you have to tell your client is that, okay, remember that this is going to be filed under a sworn affidavit, and if you're lying, okay, that's a criminal act. You can go to jail for lying on your petition. Now, that'd be pretty rare, because you've got some wiggle room to correct problems. You might have forgot to include some minor asset or something. But if you're really out to defraud your creditors, I guess, and you're a debtor, you can go to jail if you file a fraudulent petition. Now, the next, we'll talk about substantial abuse, but in 2005, as I said, a new standard was created where we assume, or presume more properly, that there's a problem. If your income is higher than the state average, so let's suppose you live in, pick a state, Montana, and let's suppose the average income in Montana is $40,000. If your income is higher than that, and it could be $6,000 or $7,000 higher than that, then a creditor can try to get the petition dismissed, claiming that there is a presumption that you should be able to pay your debts. What you have to do is rebut that presumption by showing special circumstances and no alternatives. This is the substantial abuse means test. This was created to keep people with more money from abusing the bankruptcy system. And it makes some assumptions. One of the assumptions it makes is that income is going to continue for 5 years, and that may not be true. It also looks to see if there's any way the debtor can afford to pay off the unsecured debt. And this was really put in at the bequest of the creditors at the Visa, MasterCard, American Express, banks, because they want it to be difficult to get out of debt. Abuse is not presumed if you're below state median income, although you can look for substantial abuse there. If you could prove it, you could still kick the petition. We can refuse the petition if you've been convicted of a violent crime. We can refuse the petition if you're guilty of drug trafficking or if you're not paying domestic support. All of these can come back and harm someone trying to file. Now, as I said, most petitions are voluntary, but what about involuntary petitions? When does this happen? Well, this happens when creditors have money at stake, and they've lent money to somebody, and they look at it and they say, you know something? This guy's never getting out of this debt. This guy is in a lot of trouble, and if we let him keep operating, he's going to take what assets he has left and he's going to burn through them. And by the time he is in bankruptcy, we won't be able to get anything. So we want to force him into debt. Now, there has to be, this is a bit of an older number, but there has to be about $17,000 in debt to do this. You can't do it just because someone owes 50 bucks. The debtor can fight this, but the creditors have to go into court and show he's not paying bills and that he's unlikely to ever recover. Now, if the creditors do this as a business tactic to rip off the debtor, they can be subject to some real punitive damages. So they have to be mighty sure that what they're doing is the right thing. Now, if we look at some bankruptcies, these are some of the bankruptcies, announced bankruptcies in the United States by year, and these are in thousands. These are not like that there was 556 or 380 bankruptcies, but you'll notice that the bankruptcies there, we don't have the figures for 2021 yet. I expect we're going to see a substantial amount of bankruptcy this year. I know some of the numbers I've seen say that 1/3 of all restaurants that closed for COVID will never reopen, and they'll probably go through bankruptcy. And these are only going to include public companies, private companies with public debt and assets greater than $2 million, and private companies with assets more than 10. Actually, these numbers might just be those, might not be in the thousands. I might have misspoken there. I think I did actually. So take that with a grain of salt. I won't go back and edit it because it's a good thing to see that your professor is not always right. Okay, so when you file the petition, the thing that first happens is you get an automatic stay. All debt collection stops. And really, debtors, they come into your office, they're getting ready to file. It's very tough on them. They're very haggard. They've often made great efforts to pay, a lot of sleepless nights. And all of a sudden, it all stops. All the collections stop, everything stops, and they can take this breath. Now, certain obligations are still going to get paid. Criminal actions continue. Importantly, child support and alimony continues. Also, certain payments to secured creditors can be allowed, like mortgage payments to sometimes will keep going on. At this point, we start to get all the debtors' property together. Now, one of the things we do here is that if you filed, say, June 1st, which is the 6th month, and you got a big life insurance policy 2 months later, I suppose you knew you were going to inherit money from your grandmother, and you say, wow, I owe a lot of money. I really don't want to pay all that money out. I'll declare bankruptcy now. I'll get that big check in a couple months, and it won't go to my estate. Well, it's got to be longer than 6 months away. So the estate in bankruptcy, or the estate in property, which is named all your assets that are grouped together to pay. The next thing we're going to have is a creditors meeting. This is going to be between 10 and 30 days after you file. And the debtor is going to be there, and he's going to be put under oath, and he's going to be questioned by the creditors. Now, sometimes it's very pro-formal. Sometimes it can be pretty acrimonious if people think money's being hidden or if problems have gone on. Each creditor files with the bankruptcy court a proof of claim, and it's a regular court document. They also have the possible penalty of perjury and fraud, what their name is, what their address is, what the amount of debt is. And any other creditor is going to get a look at all this, and they can say, well, that's not a real debt, or I protest that debt. Because one of the things that creditors are afraid of is that the debtor is giving preferential treatment, more about that in 1 second, to particular debtors. Now, some property doesn't get put into the pot, and this is called exempted property. Now, this is where, remember I said at the very beginning, this is all a federal court. This is where the states began to stick their toes in, where they began to have a little bit of impact here. Each state is allowed, if it wants to set up within limits that the federal government has established, how much property can exempt and what type of property is exempt. And I'm going to show you lists of exempt in 1 second. 17 states let you either choose the federal option, which is the standard option, or take theirs. Now, not North Carolina. North Carolina says you got to take North Carolina's. You're going to claim it, you got to claim North Carolina. So what am I talking about when I'm talking about exemptions? Here is a list, and these are the current exemptions, most recent ones I could get. First is the Homestead Exemption. Now, these are the federal exemptions. North Carolina's would be different than these. In most states, let's suppose you owed $100,000 in your house, and you had $50,000 in equity. You could keep $25,000 in equity out of your bankruptcy estate. Now, in the past, Florida and Texas being most notorious for this, there was unlimited amounts that they could keep out. So your homestead was unlimited. Now the feds have changed that. $4,000 worth of a car, $13,000 worth of home furnishings, no piece being over $650, $1,700 in jewelry, $1,225 in property and unused money from homestead, plus up to another $11,500 from unused homestead, another property, $2,525 in tools, certain life insurance. Pensions and Social Security are basically exempt and become part of it, and personal injury claims up to $25,000. Now, here's a surprise for most people. First of all, your 401ks are exempt. You declare bankruptcy, don't become part of it. Your IRAs and your Roths up to $1.2 million are exempt. Now, you notice that this allows some estate planning. Let's suppose you can see, I'm getting in financial trouble, and I want to preserve some of my money. I'm going to start plowing it into a 401k or a Roth. Now, there's going to be limits as to what you can put in. But what you could start to do if you thought in a year or 2 years that you were going to go bankrupt is that you could put money in. All right, the homestead. Some states are very generous. Some states place no limits. But the feds have a limit. The feds say the maximum homestead exemption, the equity you can protect from bankruptcy, is $170,000. So some states say, hey, you've got a house that's worth $150,000 that you've paid off. We're not talking the secured, we're not talking the mortgage here. You've paid it off. We can't touch it to $170,000. But if it was a $200,000 house, yeah, we can get $30,000 in equity there. Now, North Carolina is not that generous. North Carolina gives you, it depends. If you're an individual, you can claim a $35,000 individual homestead exemption. You've got joint property with a spouse, $6,000. You're a widow, I believe it's a widower as well, $70,000. Cars to $35,000, qualified college accounts, and those they don't have the tax advantage they used to have, so they're a little bit rarer, but $25,000. Retirements and pensions are exempt. Tools to $2,000, personal property to $5,000, all those. All right, so as I said, you make a pile of all this money. Who's in charge of it? Well, if you're dead, it's your executor executrix, sometimes called the administrator administratrix. Here we call it the trustee. Now, there is a U.S. trustee. He is initially appointed, and he's the interim of provision, and he can be confirmed, or the creditors can say we don't want him. But his basic duty, or her duty, is to make this pile of all your money, all your assets, sell it off and pay the creditors. For most bankruptcies, the initial or interim trustee, which is appointed by the court, becomes the permanent trustee, and he handles it. But sometimes they want an expert. Now, the trustee has very broad powers. He is the same as a lien creditor. He can come in and he can take anything that's not secured creditors, and he can get control of it. He has the same rights as the debtor, so he can object to a debt because there was fraud or duress or incapacity or mistake. He can go in and he can just void those out. The big thing, and this I mentioned a little earlier, is preference here. Let's suppose you're getting ready to go bankrupt and you owe, you borrowed $100,000 from a whole bunch of people, 10 people, one of whom was your favorite Uncle Fred. And you say, my business isn't working. I can see that in a year or two I'm going to be bankrupt. What I'm going to do right now is, I'm getting ready to file. I do owe Fred $100,000. I'm going to pay him completely off. So you take the money, pay $100,000, and a month later you declare bankruptcy. Okay, was it a legitimate debt? It was. but it was an unsecured debt. So the debtor, okay, paid off someone in preference to these other people and then declared bankruptcy. The trustee can go in for up to a year. Sometimes it's just 90 days, unless there's but for up to a year, and he can void that and get the money back, and it becomes part of the pot. Now that means Fred's going to stand in line like everybody else. Of course, like I said, if you did it a year and a day before, trustee doesn't have that power. If there's not this close relationship, if there was a good reason for it, this was a bank, it was a Hail Mary, who's trying to preserve this last little bit, fine, we're good. Trustees can block landlord liens. Trustees can avoid non-perfective liens as of date of filing. Any fraudulent transfers made within 1 year are voided. The big key is, are they equitable? Trustees can look at where you moved money and ask, was it fair? Did they leave you with a better chance of survival? And if they weren't, very often they can push back and really get those back in to the estate. All right, so you've made this pile. Who gets paid first? Well, the people that have a secure debt. So the classic example here is the mortgage company. They lent you $10,000 on your house. They have a $10,000 mortgage. They're going to get paid first. And I've talked about secured creditors in regards to, security agreements and stuff in previous chapters. Anybody that has any sort of collateralized claim on property, secured creditor, they're going to get paid first. When they all get paid out, usually from what's secured, okay, then we go to the unsecured creditors. And those are going to be classically American Express, Visa, MasterCard, Discover Card. Okay, so here's the actual way it goes. First, the cost of bankruptcy gets paid. Then you go to the involuntary bankruptcy expenses if there were any. Then wages up to $13,600. Then employee contribution benefits of $13,600. Then there's farmers and fishers get another $6,000. Consumer deposits, paternity, alimony, maintenance, support debts, taxes, and then we start to get to the general creditors. If there's anything left off, if we paid everything out and, believe it or not, all the debt has been paid out, at the end of the day, the debtor can get some money. Not terribly common, but let's suppose you were paying a debt that had substantial penalties for early payment. Well, you could pay that off in the bankruptcy, and it might make more sense. There's nothing wrong with planning a bankruptcy. People do it all the time. Famously, former President of the United States, Donald Trump, has used bankruptcy as a tool. At the end of all this, you get a discharge certificate, and it says, okay, you don't owe this money. But if we find fraud or dishonesty within 1 year, we can reactivate the debts, essentially. If anybody had co-signed any loans with you, they're not discharged. So guarantors, which we've talked about, insurators, they have no protection under this. They still owe the money. Exceptions to discharge. What can't you get rid of? What debts? Well, here's a big one, back taxes. Up within the last 3 years. Usually they won't let you accrue too much more than that. But so some people, plan bankruptcy. What they did is they said, oh, I can't get out of my bankruptcy debts if they go owed to the government. So I'll tell you what I'll do is I'll get some cash advances on my Visa, FedEx, and I'll pay off taxes that way, and then I'll just discharge those. Can't do that. Any debt you took under false pretenses, a property. Any creditors weren't listed because of what you did. So people you omitted from the list, they're not going to be exempt. Fraud or misuse of funds while you were in a fiduciary capacity. Alimony, child support's not dischargeable. Torts are not dischargeable. Fines and penalties not dischargeable. Student loans. Now that's a huge one because that's among the biggest chunks of debt out there in the American economy. The big ones are, of course, mortgages, unsecured creditors like Visa, MasterCard, American Express, and student loans. Student loans have been bigger than that, Visa, MasterCard, American Express. Not dischargeable unless you prove undue hardship, which is not easy. Consumer debts for luxury goods up to $1,000, cash advance debts up to $1,000, and DWI, non-dischargeable. Sometimes the court will pay out the money and then deny the discharge. Why? Because there was concealment, destruction, or delay. There was fraud or destruction of records. All of those will get you. The other big thing is you can only declare bankruptcy every 7 years. So if you got a bankruptcy within the last 6 years, you don't get another discharge. At the end of the 6 years, 364 days, okay, on your 7th year, now you can declare bankruptcy again. You can only do it once every 7 years. Now that's the liquidated bankruptcy. Let's talk a little bit about the reorganization, which is called an 11. 7 is the straight bankruptcy, 11 is reorganization. This is often used by corporations. I saw that Hudson Belk, which is no longer owned by the Belks, they sold it out. They sold it out for $3 billion. And what happened was, to buy it, the people that bought it borrowed against the value of the corporation. They borrowed $2 billion to buy the Belks out. They bought it for 3, I think. So they put some money in to pay them out. But then they used some of that money to pay the purchase costs. It's pretty common. That meant that Belks had a lot of debt all of a sudden. And now Belk can't meet some of its obligations. So what it wants to do is reorganize. It wants to get rid of some of this debt. It's going to try to get rid of, I think, about $400 million of it, if I'm not mistaken. And then try to reorganize and come out the other side as a viable business. Whether they can do this or not is anybody's guess. I haven't seen the books. I just read about this. When you do an 11, usually, often, not usually, but often, they will leave the person who is running the company still in charge, and he's called the DIP, the debtor in possession. Now, sometimes the court will say, no, there's gross mismanagement, we're going to leave the DIP in. But if he is in, if the debtor is still in possession, he gets all sorts of strong arm powers, just like the trustee. He can do things he couldn't do the second before he declared bankruptcy. One of the big things that they can do, and airlines are notorious for this, is they'll go into reorganization and they'll break union contracts. They'll say, okay, these collective bargaining agreements, they're done. I know we had a 2-year contract and you gave us a lot of money the first year so that we could do some stuff, and the second year you didn't take any raises, and the third year is supposed to get a big raise under this. Well, it's the 3rd year and we're going to declare bankruptcy. You're going to have a creditors committee formed, and it's supposed to advise the DIP on how to get out of debt if possible. The DIP comes up with a reorganization plan, and it'll designate what classes or claims are represented. It'll set up, basically, here's who owes what, different classes of debtors. And generally, the DIP has 4 months to 6 months to get the plan together, get it functioning, and if not, we can come up with one and make the DIP use it. Now, if there are multiple classes, suppose you got secured creditors, unsecured, that'd be the simplest breakdown. If more than one group objects, sometimes you can still force the other groups to take it. It's called cram down, without going too far into that. Okay, now 13 is a relatively a new one. This is open only to individuals, not to corporations or partnerships. And what this says is, if you owe about $1.2 million in unsecured debt, in secured debt, and about $400,000 in unsecured, you can declare. Anything above that, you can't. The big advantage of a 13 is they're quicker, only voluntarily, and you basically agree to turn over future earnings. And then you pay off, essentially, one of the things you can do here is if you've got high interest rates, you can really negotiate a lower rate here because you set up a repayment plan. You have up to 3 to 5 years to pay off a lot of these debts. 5 years was the max under the 2005 laws. The court will hold a confirmation hearing. If secured creditors are happy with it, then if necessary, the debtor can turn over the secured claims. But if not, they're gonna take it. Now, if there are objections to it, if they don't like it, but if you say, well, too bad, if I'm going to use my income here and the debt will be paid off is equal to the amount of the claim, you got to take it. So 13 has certain advantages. I'm not going to go too far down that path. You are allowed to modify the plan if you don't think it's particularly fair. You can't get out of those non-dischargeable things though, like alimony we talked about before. Those are all pretty much there. All right, the last thing to talk about, and I wanted to keep this right at half an hour. It looks like we're going to be able to. Is that the farmers and fishermen have a Chapter 12. Now, I'll be honest, I've never done a 12. But it covers people who get at least 50% of their income from the farm. Now, one of the problems with that is that not many people are full-time farmers anymore. If you went to the turn of the century and you said, okay, how many people are farmers in the United States, you get high numbers. You get 20 or 30%. But if you come to today, you're going to see really small numbers. It is just not common to see high numbers of farmers anymore. It's minuscule. Even farmers that exist, very often they earn a lot of their money off the farm. Okay. Fishermen, again, 50% of the income has to be for fishermen. You've got some maximum. One of the things that changed, by the way, for farmers is that President Trump raised their debt to, they can get out of it if they owe up to $10 million, which is, a pretty big farm. Like I said, I've never done one, so I don't want to speak too much from my own ignorance. Okay. Right around half an hour. Hope you enjoyed it. Whenever you're ready,